Welcome back to the structure of the federal judicial system, part 2. Again, there are 3 levels to the federal court system. We're not going to talk about state and local governments, just the federal system. It is very important to outline the structure of the federal courts and the major responsibilities of each component. The district courts, or the courts of original jurisdiction, we've already discussed what this means. They are the trial courts, the only federal courts in which trials are held and in which juries may be impaneled. Approximately 98% of all criminal cases in the United States are heard in the state and local court systems, not in the federal courts. The 678 district court judges usually preside over the cases alone, but certain and very rare cases require that 3 judges constitute the court. Again, jurisdiction, the authority to hear a case. Why would courts go to the district courts? Cases involving federal crimes, federal civil suits between citizens, and so on. District court judges rarely post their decisions or publish them to the public, but they are accessible. A distinguishing feature of the American legal system is the relative ease of the appeals from the district courts. U.S. law gives everyone a right to an appeal to a higher court. The loser in a case only has to request an appeal to be granted one. So just the request will constitute an appeal. Of course, the loser must pay a substantial legal bill to exercise this right, as it costs the courts a great deal of money for the cases to be appealed. So let's move on to the next level of the court system. After cases are heard in the district courts, the loser has the opportunity to appeal their case. If the appeal is successful, then they are granted a new case to go to the U.S. Court of Appeals. They have what's called appellate jurisdiction. The U.S. Court of Appeals are empowered to review the final decisions of all district courts. They have the opportunity to either uphold the lower court's decision, remand the case back down to a different district court with a different judge, and the loser can have a new trial, or they can move the case on up to the Supreme Court. About 75% of the more than 61,000 cases that are heard in the courts of appeal come from the district courts. The United States is divided into 12 judicial circuits, including one for the District of Columbia, so technically we have 13 courts of appeal. Each circuit serves at least 2 states and has between 6 and 28 permanent circuit judgeships, so 178 in all, depending on the amount of judicial work in that circuit. Each court of appeal normally hears cases in rotating panels consisting of 3 judges, and decisions in either arrangement are made by majority vote of the participating judges, so 2 out of the 3. There is also a special appeals court called the U.S. Court of Appeals for the Federal Circuit, which hears appeals in specialized cases such as those regarding patents, copyrights and trademarks, claims against the United States as a whole, and international trade. The courts of appeal are able to correct errors of procedure and law made in original cases. They also set precedent for all of the courts and agencies within their jurisdiction. The highest court in the federal system, the United States Supreme Court, is also the only court specifically established within Article 3 of the Constitution. There are 9 justices on the court. 8 of them are associate justices, and there is 1 chief justice. The size of the court is not set in the Constitution, and it was altered many times between the 1801 and 1869. Some of the important functions of the Supreme Court involve resolving conflicts among the states, maintaining national supremacy in the law or upholding the Constitution, and playing an important role in ensuring uniformity in the interpretation of national laws. All 9 justices will sit together to hear cases and make decisions. The Supreme Court has what's called original jurisdiction, as well as having appellate jurisdiction. Very few cases arise under original jurisdiction, which is defined in Article 3, and almost all the cases come from the appeals process. Cases appealed from the state courts, or cases that are appealed from the state courts, must involve a substantial federal question. We've discussed these items in class. Finally, I just want you to take a moment to look at the chart to see how cases actually reach the Supreme Court, the path that they take, as well as where the cases begin and why they go to the federal courts. Thank you. That is the end of part 2. Stay tuned for the next video lecture on the politics of judicial selection.